Good morning and Dumelang. My name is Botsalo Tamuku from Botswana, representing the Ministry of Land Management, Water and Sanitation Services, specifically from the Department of Water Affairs, the Communication Task Team member for ORASECOM. Yes, so we are here representing the country to take part in the International Water Law course that has been organized through the help of WaterNet and the GIZ and the ORASECOM. You see, coming here as a country, it's very important to us because Botswana, as we might all know, is a landlocked country, and we share a number of rivers with the other countries. We share the Okavango River, we share the Limpopo, we share the Zambezi, and we also share the Orange River. So it's important for us to be having such an exposure so that we have an understanding of how we can relate and work well with other countries in terms of the shared water courses that we have with the other countries. And coming here, our expectations is to get a deeper understanding of the SADC protocol on shared water courses. Also understand how the UN Convention of Shared Water says, so that when we go out and plan, we have a good understanding of how we can share this water peacefully with other countries around us. And I'm hoping by the end of the day, we'll have a good conversations with our colleagues from the other countries, and we'll plan particularly well for all the shared water courses that we have with them.
My name is Peter Wanamate Ntatakane. I come from the Kingdom of Lesotho. I work at the Ministry of Water at the Water Commission. Here at the Orange-Senqu River Commission, I'm in tasked to be the technical task team member, and we are here today for attending the course on international water law as organized by the WaterNet. The mission is coordinating all the water sector activities for the whole country, and it's overseeing the water law and every aspect regarding to water, and it's an advisory body to the ministry on all issues regarding the country's water resources. That Lesotho is a riparian country in the Orange-Senqu River Commission. In other words, Lesotho shares the river basin of Orange-Senqu River with 4 countries. It is quite important that issues of international nature governing the sharing of the shared water resources, that we should have be well apprised actually, and have a clear understanding, maybe based on examples from other countries whereby such cooperations benefited the countries in a similar manner. As we know, water can easily become a source of conflict for countries which are sharing that. So I think this course will really give us an insight of such issues whereby at least we can really optimize the use, the sharing of water resources in a peaceful manner, or water be for peace rather than conflict. Yeah, in fact, as it's globally known that the fresh water is finite. In fact, it's becoming a very scarce resource in the fact that population is growing, but the water is not similarly growing with the population. So the holistic management of the available freshwater resources is quite important. Secondly, as we see the way things are changing, like issues like climate change are putting pressure on our limited water resources. So it's very important that really we holistically manage our water resources in such a way that really we should have these resources for even the future generations. Indeed, we are quite aware that Africa, even in my country where I come from, the water resources is subjected to a lot of pressures, things like pollution, things like droughts, and those are which some of them we don't have control of, but at least trying to manage these things well in advance can really make a significant impact.
My name is Professor Owen McIntyre of the School of Law, University College Cork, a college in the National University of Ireland. I'm an environmental lawyer with a particular research interest and expertise in the area of international water law. I'm here in Johannesburg for the next few days offering or delivering a 3-day training program on international water law, the core principles, the essential rules, the developments, the trends in the field of law relating to the management of shared international water resources. And I'm doing this on behalf of WaterNet to staff and stakeholders of the Orange-Senqu River Basin Commission, ORASECOM. Over these 3 days we're going to cover a whole range of topics: the basic sources of international rules in this field, the key rules and principles, substantive and procedural, the rapidly emerging rules on the environmental protection of international rivers, and of course the protection of their broader ecosystems. Looking at the institutions, of which of course ORASECOM is a prime example, but looking at the cooperative institutions which assist states to cooperatively and collectively manage shared water resources. Well, the water situation globally is becoming quite serious, and in Africa, Africa is at the sharp end of that, Southern Africa in particular. Water consumption is rising inexorably. You know, we're using more and more water. We need it for food, we need it to produce energy. Our lifestyles are changing and demanding more water. The nature of food production is changing and demanding more water, with more reliance on meat, for example. Industrial uses are also rising, so mining, manufacturing, and a whole range of other processes. I think we often fail to fully appreciate how water intensive many industries and services and products actually are. Global warming is complicating this significantly. And we're looking at greater water stress in the Southern Africa region as the line of plentiful water is likely to move north. Those are the predictions in the context of global warming. Southern Africa international water law is particularly important in Southern Africa because many of the key river basins are shared basins, shared among a number of states. The greatest example being the Zambezi, shared among 9 states. The Orange-Senqu River Basin, a hugely utilised river basin, very intensively used and very intensively regulated, and it's shared between 4 states. Cooperation is terribly important here in Southern Africa over those resources to try to optimise their sustainable use. Now, having said that, Southern Africa provides an example of very good and very effective cooperation among states. States here have probably provide a shining example to the rest of the world as to how states can actually cooperate proactively and in good faith with each other to try to optimise a scarce resource. So there's much to be learned from the cooperative patterns in Southern Africa, and ORASECOM would be one of is the most developed cooperative mechanism in this region and one of the most developed in the world.
My name is Amalia Shikongo. I'm from the Office of the Attorney General in the Republic of Namibia. I'm a legal advisor and also a member of the ORASECOM legal task team. So my expectation for this course is that being a new member to the task team, I really expect to learn the basics of international water law. And I'm hoping that at least we'll learn from the international perspective as well as from the regional perspective. The water situation in Namibia is, I think, it's a situation which really need more attention, because we at the moment do not have enough water, because as you know, we have gone through drought over the past years, so we really need to manage the water resources effectively.
Matibelo Khasipe from Lesotho. I work for the Ministry of Water in Lesotho, Water Commission, and I am a lawyer there. So this is international law training course that we are attending, and from it I'm expecting to know international trends with respect to how water is shared between different countries. I'm expecting to learn more about international trends and how we can keep abreast so that we deal with the Orange-Senqu River appropriately as far as legal commitments are concerned. Due to droughts, especially in our southern countries, southern region, the water situation is really something that is to be taken seriously, and we really have to preserve water and to use it at least to share. Like, the sharing component is very important, because if we are upstream and we cannot share water with the downstream countries, how are we expecting people to survive?
My name is Mutika Mohale. I come from Lesotho. I work for the Ministry of Water. In the department, in the legal department. I have 11 months now in that ministry. I must say that I haven't done international law at the university. It will be an interesting for me to learn so much about international law. Thank you so much.
Thank you, Dada Pule. My name is Peter Monamaten Tatangane from the Kingdom of Lesotho. I am from the Ministry of Water, like the team Mohale, but from the Water Commission. I am the technical task member of this river basin, which is Orange-Senqu River Commission, since its inception. Thank you.
My name is Mamkete Mugwena from Lesotho, from the Department of Water Affairs as Water Rights Officer.
I'm Mansa Mokoka from Lesotho, Ministry of Water, as a legal officer.
My name is Ntiale Tapu. I also come from Lesotho. I work for the Department of Water Affairs in the water law section. Thank you.
Morning, everyone. My name is Sakile Mdaweni. I'm from Republic of South Africa with the Department of Water and Sanitation. I work with groundwater planning. In this ORASECOM, I represent the groundwater trust team. Thanks.
Hello everyone, my name is Elizabeth Kutsatse. I'm a lecturer within the Faculty of Law, Department of Private Law at the University of Zimbabwe, and I take a module on international water law within the Department of Security.
Good morning, everyone. My name is Matibel Wakasite. I am from the Ministry of Water in Lesotho, from the Department of Water Commission as a legal officer there. Thank you.
My name is Amalia Shikongo. I am a legal officer at the Office of the Attorney General in the Republic of Namibia. I'm also a member of the ORASECOM legal task team.
Good morning, everyone. My name is Dolly Kandiri Kirira. I'm a senior legal officer from the Office of the Attorney General, Directorate of Legal Advice.
My name is Wazalo Tamuku from the Department of Water Affairs in Botswana. Just like in Daden Tax, I am one of the old furnitures of ORASECOM from the communication task team.
Good morning, everyone. My name is Itzansa Wone from Botswana. I'm a geophysicist in the Groundwater Division of Department of Water Affairs, and I'm also a member of Groundwater Hydrology Committee of ORASECOM. Thank you.
Good morning. My name is Wahan Savan from Botswana, Department of Water Affairs, working as a hydrologist, a member of Technical Task Team of ORASECOM.
Good morning, everyone. My name is Boniface Mabeo. I'm from Botswana, from the Ministry of Land Management, Water and Sanitation Services. I work as a public relations officer in the ministry.
Good morning. My name is Hutso Nelisiela. I'm the legal advisor in the Ministry of Land Management, Water and Sanitation Services in the Republic of Botswana. I'm also a member of the legal task team for ORASECOM.
A very good morning. My name is Uki Bukamosobolele. I'm also from Botswana. I am from the International and Commercial Division of the Attorney General's Chambers.
Good morning. My name is Seisha Masala Mabeza, Senior Attorney in the Ministry of Land Management, Water and Sanitation Services, based at Watolen Board. Thank you.
Good morning, everyone. My name is Kraspos Kujinga. I'm the Programs Coordinator for WaterNet. Thank you.
I want to talk about what do we mean by international water law? What are the sources? You know, what are these rules and where do they come from? Where do we find them? And it's important, I think, just to explain where they come from, how we understand them, and how we find them. So this is the introduction to the sources of international water law. And water as a key natural resource and environmental element is moving very quickly. And we're finding new kinds of rules. Rules are coming from different places. The old established patterns of making international law are changing. We have lots of rules and standards coming from lots of different sources. But I just want you to note this fact that the traditional patterns are changing. So I want to talk about the classical sources of international law. And we have classical sources. Treaties, or we can call them agreements, or we can call them conventions. And sometimes within that category we have protocols. There's a distinction that I'll explain. So agreements, treaties, conventions. Conventional law or treaty law. That's the key one, if we have them. And then we have others like custom. And then we have secondary sources like the statements of courts, international courts, and what we call soft law. So we look at those. Look, soft law is not really a classic source. And then we have, why is water law different? And this is true of many environmental laws. What's different about it? And it's the unique challenges. You know, that it's a very complex issue. Often the challenges are urgent. You know, there's nothing as urgent as needing water. That's not something we can sit down and, set 10 years to arrive at a solution. That's not a possibility. It is in other fields of international law. So there's an urgency. The issues are often global. Similar problems are although shared water resources are not global. They are, regional or bilateral or trilateral. But the problems are global. There are boundary issues here. A problem over water is rarely, between states, is rarely a problem over only water. It might involve elements of trade. It might involve boundaries and territory. It might involve security. It might involve investment. It might involve a whole range of other questions, of other areas of law. So the boundaries are not simple. So we have to reconsider these classical sources and see what other sources of law we have. We have innovative lawmaking. Now I say beyond Article 38.1. What is Article 38.1? Article 38.1 is an article of the statute of the International Court of Justice. One of the things you have to remember with international law is nobody organizes international law. There's nobody in charge. Who decides what international law is? Who makes international law and imposes it on states? Nobody does. Sometimes when you meet people from the UN, they think they do, but they don't. The UN makes the coffee. States make law. Only states can make international law. If you want to have a conversation, and we will, I hope, a conversation over the next 3 days on international water law, the first word I want you to bear in mind is a word called sovereignty. Sovereignty. Anybody understand what sovereignty means? We probably have a different idea of it. Sovereignty. Anybody put their hand up and say, I think it means? We'd probably all have different answers if we did, and it's early to be throwing that at you. We'd probably all have a different understanding. But sovereignty essentially is what it is to be a state. It's the power that we ascribe to a state, that a state assumes. And very much part of that power, the power we're concerned with, is the right to enter into negotiations, the right to engage with, to deal with other states. That's what states do. States deal with other states. Internal sovereignty means that states control everything inside their borders. They are in charge of people, in charge of making national law, they're in charge of the resources within their territory, its protection, its the exploitation of those resources. States are in charge of everything in their territory, people, resources, economy, laws. But when it comes to things outside of their territory, when it comes to engaging with other states, as they have to do, this is a globalized and increasingly globalizing world. All of those interactions with the other states are done by a state because that's part of its sovereign responsibility. It's part of its sovereign duty or sovereign function. Now, what that means is you can't impose international law on a state. A state has to accept international law. So there's nobody running this. There's no one authority running this. So we don't really have one source of what do we mean by international law. There's nobody to say it. The closest thing we have is a charter, which is a statute, which is effectively a treaty, setting up the International Court of Justice. Going back to the 1940s, after the Second World War, a new court was set up under the UN system to settle disputes between states. Now, states cannot be forced to go. States have to volunteer to go. You can't drag a state by the ear. Come on, we're going to deal with you now. No, of course not. So it's only there if states want to use it. But you had to set up the rules for this court. And one of the things that you had to define in the rules was, what are the laws, what are the rules that this court will apply? And in Article 38.1 of that statute, they set down what the rules are. And that, of course, has come to be understood as a definition of the sources of international law, a definition of where we would find international rules. Civil society has no personality. Only states exist. Civil society and other entities don't exist. So how do we explain that they're now involved? Things are changing. And that's what I want to capture, is that this is changing. The picture is becoming a little bit fuzzier. For the better. So this notion of innovative lawmaking, soft law instruments, and responding to technical complexity. And think about what a river basin organisation is. You know, states agree, we will only use a river, a shared river, in an equitable and reasonable manner. And they sign an agreement, and they ratify the agreement, and that becomes the rules. Does that actually mean anything? It means nothing, because you would have to have specialist institutional structures. You would have to have a body that understands the basin, that is responsible for monitoring and studying the basin, for facilitating exchange of information. You can't manage, you can't regulate what you don't even understand. So we have to start with machinery, institutional machinery. And that institutional machinery, in its everyday actions, by developing practices and procedures and guidelines and doing various things, it itself is making laws. So, you know, technical complexity leads to specialist, often law-making institutions, formally or informally. We have this problem of multi-level governance, that states are no longer the only actors. If you wanted to build a big project, a big construction project, and a lot of where this law becomes relevant is when a project is proposed. And another state says, whoa, we don't like the idea of your dam, it's going to cause problems downstream, it's going to impact on our water supply, it's going to have ecological impacts, this is going to happen, that's going to happen. So, but when the proponents of that project, when a state or even private entities, private investors, come up with the idea for that investment, is the first thing they think of, oh, I wonder what the ORASECOM agreement says here, I wonder what the SADC protocol says. Probably not. Probably the first thing they think of is, what are the World Bank rules on this? Because we need cash to build it. Or what does the African Development Bank require? Or what do private sector banks that are members of the Equator Principal Banks, which apply World Bank standards? So often there are other rules that you have to consider because that's how you access the capital for the investment. So the first source is conventions, treaties, agreements, right? And we can include protocol. A protocol, the distinction between a protocol and a convention, or a protocol and a treaty, is that the convention or the treaty is the main agreement. And agreements are very often broad. The agreements are very often very general. A treaty is very often, or a convention is very often very general. And then we wait to put the detail in a protocol. A protocol is adopted by the parties under the convention. Think of climate change. We had the UN Framework Convention on Climate Change in 1992. It didn't really say anything except that the states commit to move forward, and they identified principles that would guide what states did. But then it was the Montreal Protocol that had the detail. The meat was in the protocol. Right? And often the protocol will deal with a specialist topic. So think of the SADC Agreement, the SADC Convention, and then think of the revised SADC Protocol, the 2000 revised SADC Protocol on shared water courses. The meat is in the protocol as far as water resources are concerned. So we have a whole range of the UN Water Courses Convention. Now these are the key agreements at the international level. The UNECE Water Convention, 2 global conventions, because the UNECE Convention is now a global convention. We have the revised protocol, I give an example of ZAMCOM, of course ORASECOM, any of these, the Boundary Waters Treaties in the US. Now, treaties are strange creatures. We've got 2 types, I suppose, no, we've got loads of types, but they're on a spectrum in terms of their generality. So, we have treaties that are global. And what they aspire to do is to create general rules that will apply globally. The UN Water Courses Convention. Has people heard of the UN Water Courses Convention? The 1997 UN Water Courses Convention. So this is a global agreement. Now there's about 36 parties to it, states that have ratified it to date, but it largely encompasses generally applicable customary rules, so it's relevant whether we've signed it or not. Now, we often refer to that as treaty legislation, because it's a bit like legislation. It seeks to create a general rule, a bit like the law, a statute or a law in a national country. It seeks to create general rules applicable to the whole community. So on one level, the big global treaty legislation. And then on the other level, you get a bilateral, say 2 states share a river. And the agreement is very much, we will limit our pollution or our abstraction or our management or our use of the water in this way if you do the same. So it's just between 2 states or 3 states or 4 states if you think of ORASECOM. And if you limit it, we limit it. If you do this, we do that. If you manage the ecosystem, we manage the ecosystem. And that, we refer to that as a treaty contract. That's much more like a contract. If I do this, you do that. If I give you $1, will you give me a newspaper? It's a contract. It's like a deal. And it's based on what we call reciprocity. These obligations don't apply to me. I'm free of these commitments if you fail to meet them yourself. So all the way from the big global instrument that sets down general rules to the small instrument that's only between 2, 3, or 4 parties. So we have a whole range of different types of treaties. Now the nice thing about treaties is, remember we come back to sovereignty. Sovereignty, states, all the power starts and ends with states. So to the extent that international law matters, it has value, it has legitimacy. Why? Because states get it legitimacy. Because all that legitimacy comes from states. We live in a sovereign world.